The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, ladies and gentlemen. Welcome to the Contracts 101, Choosing and Completing AIA Owner-Contractor Agreements. This is a webinar brought to you by AIA Contract Documents on how to complete an AIA 101 2017 document. This presentation is protected by U.S. and international copyright laws. And this program is registered with the AIA for one learning unit. When you registered for this course, you entered your AIA member ID number, if applicable, and we'll use that information to report your credit within 2 business weeks of the webinar today. You'll also be receiving the PowerPoint and recording from today's webinar by close of business tomorrow. So again, you will receive a follow-up email with the PowerPoint and recording and a short survey, and your credit will be reported directly to the AIA within 2 weeks. Just a disclaimer slide to indicate that this information is not provided as legal advice, so please always consult with your attorney. And before I turn it over to our presenters, just a note that all attendees are currently muted. Please use the question box in your GoToWebinar window to ask any questions. We will then, at the end of the presentation, time permitting, answer any questions that we can. I will also indicate that if you have audio troubles at all during the course of this webinar, you can go to the audio panel on your right-hand side and select phone call and use your telephone to dial in. If you have audio issues, it's typically because of computer audio. So with that, I'm going to now turn it over to one of our presenters, Peter Longley. Peter?
Good afternoon, everybody. So just a little bit about me. I'm with CBT Architects. We're a Boston-based firm, about 200 people. And I'm also a member of the AIA Documents Committee. I joined the committee in 2015, and I was a part of the task group that worked on the development of the A101, which we're going to be going through today. Jim?
Yes, thanks, Pete. Jim Bedrick. I'm an architect by trade, but I've worked all 3 sides of this industry, including 10 years with Webcore Builders, a major general contractor in San Francisco Bay Area. I've been a member of the Contract Documents Committee since 2008, and among other things, I worked on the 2017 release of the A201, which we'll talk about in a minute here because it is usually coupled with the A101. Pete? So what we're looking to do today is, first of all, we want to look at the various owner-contractor forms that are available. There are quite a few of them for various and sundry different purposes. Want to develop a basic understanding of the elements of these agreements and then learn how to fill them out. There's a lot of information that is required of the people who are executing the contractors to enter into the document before they actually sign. And then we'll look a little bit at the resources that are available to help you do just that. Next. Now, the AIA Documents Committee, or the AIA Documents Program, has been going since 1888. It really has become the industry standard, is used much more than any other published agreements. We have an iterative drafting process where most agreements are updated every 10 years, and during that time we collect information on industry trends and practices and so on. So the documents are kept in alignment with current practice. Participating in this effort, we have market researchers, industry stakeholders, of course, resources within the Institute. We, for major documents, we put together liaison groups of industry experts that we look to for advice, other subject matter experts, and then, of course, the Contract Documents Committee itself. Next. So there are, as we mentioned, several owner-contractor agreements available. So let's look at them by family first. Next. There's the conventional one, the design bid build, the usual, the very common hard bid process. Then there are two that deal with the construction manager scenario. One, the CMC, or it's also called CM at risk, is where what is basically the general contractor participates throughout the design process and the construction process. And then there's a CM as advisor, where again there is a person or entity that brings construction expertise to the table, participates through the design and construction process, but doesn't have a financial stake in the process. There's a design build contract in which one entity does both the design and the construction. This is becoming more popular now. Many public agencies, including most of the states, now allow some forms of design build. And then there is integrated project delivery, which is more than an owner-contractor agreement. Signatories to this agreement also include the architect, their major consultants, and the contractor's major trade contractors. Next. So we call this the A201 family because these agreements depend on the A201 for the general conditions. Basically a more detailed look at how the project proceeds. So there are 5 of these. Next, Peter. So the first 3, the A101, 102, and 103, are the basic agreements. The 101 is what we call a stipulated sum or a hard bid contract. The 102 and 103 are forms of cost plus contracts, where the contractor is paid the cost of the work plus a fee, often stated as a percentage of the cost. The 102 has a cap put on it that the owner will not be required to pay anything more than that guaranteed maximum price. The 103 is wide open. The owner doesn't necessarily have a limit. Next. These all depend then on the A201 for the detailed general conditions. So the A201 is incorporated in these 3 by reference. Next. Then we have 2 shorter versions. They're actually more pages than the 101 or 102.3 themselves, but these include abbreviated versions of the general conditions themselves, so they don't need to be paired with the 201. Next. Next. So we're going to look at the A101 specifically. Like we said, there are other versions, but this is the most common, and this will allow us to hit all of the elements, or most of the elements that are in any of the other documents. The way it's organized is, first, there are a description of the contract documents, what's included there. There's a definition of the work of the contract, and that's the actual project which is going to be constructed. It sets dates of start and finish of the project, and specifies, of course, the sum, the amount that the owner will pay. Article 5 then goes into how that will be paid, how we determine progress payments. And Article 6 gets into resolution when things go sideways and we can't agree right away. Article 7 deals with termination or suspension of the project, which has become quite an important thing these days with the current pandemic, quite a few projects have been terminated or suspended during that time. Article 8 has miscellaneous provisions, and then Article 9 is the enumeration of the contract documents. Contract documents, of course, include the drawings and the specifications, and often other items. And they need to be, if something is to be part of the contract, it needs to be listed succinctly with a title and a date. Exhibit A then covers insurance and bonds, and we'll go into that in a little bit more detail in a few minutes. Article 1 and 2 then are pretty much boilerplate, and the rest of them all require input from the people who are executing the agreements. Peter?
Yeah, we should just mention that Exhibit A is a separate download, but if you're buying the document one at a time, you will be entitled to do that download to get your Exhibit A, and so it exists as a separate Word document for editing. So we're going to go through the items that are to be completed in the contract. So we start with the date of commencement, and there are 3 different formulas that are indicated in here. You can pick a hard date. It could be the date that the contract is executed. That's the first choice at the top. Or it could be that the attorneys have gone through and got this thing all fixed up, but you haven't quite yet figured out when you're going to start. So you could say that the second choice is a date that's set forth in a notice to proceed issued by the owner, which will come separately after the contract is executed. Or lastly, there might be some other means. Perhaps it's more complicated. Perhaps there's 2 or 3 things that have to happen first before the project can be authorized to proceed, and all those conditional statements can be typed there in that third choice. So the date. And the way AIA works is if you're filling this thing out and you left this blank, then the date of the contract will be the date of the commencement. So AIA, I think, does a pretty good job of putting default positions if the contract's not filled out properly. And then lastly, of course, the contract time will be measured from the date that the project commences. Substantial completion, now that is defined in A201, which is a reference document, and that is the date on which the owner can legally occupy the building for its intended purpose. And it might not be the entire building, it might be a portion of the building. So you might have some wing of the building or separate floors, or if the project is multiple buildings, perhaps building A is going to be complete before buildings B and C. You can put in here in section 3.3.2 any series of complicated ways of describing how your project is to be completed there, and you can indicate what the substantial completion date is for those portions. But now, as to the main calendar date, you remember back when you were filling in the date of the contract. So if you didn't have a date known, you might choose choice number 1. It's not later than a certain number of days after the job commences. Because at the time of execution, you might not know when the notice to proceed is going to be. Or likewise, you can just simply put in a fixed date. That's your second choice. Say the project has to be completed August 31st so that the school can open the following week after Labor Day to begin classes. So there might be a reason to have a fixed set date for substantial completion.
So the contract sum then is the amount the owner will pay, and this can be modified in several ways. The first one, next, Peter. there are two versions of alternate, and then there are allowances and unit prices. The first type of alternate is one that we have all agreed on before we sign the contract. Owners often want bidders to suggest alternates if they think they've got an idea of something that might be cheaper or last longer, something like that. And they'll suggest it during the bidding process, and then before the contract is signed, we go ahead and include that in the contract sum. And that's, you see that right there, it says it's already included in the sum. The second then is something that we talk about before we sign it, but we don't really come to an agreement yet. It might be something that, like, there's a material that might become available, for example, but we'll need it by a certain date. So the conditions for acceptance over there is that it's available by, say, September 1st. And then if that is accepted, that alternate is accepted, then we need to include it in the contract sum by a change order. Next. So an allowance then is a lump sum that's included in the contract when the price of an item can't be determined before we sign the contract. So as an example, we might know how much dirt is going to be excavated, but we don't know the subsurface conditions. Okay, so we'll put in a number here that we think is going to be close. Estimators often call this a plug number. Putting a number in there will get the overall sum closer to reality than leaving it out or putting it in as zero. After the fact, the contractor will be paid the actual cost, not the allowance. So it might be more than the allowance or less, and that number is then included in a contract sum by an additive or deductive change order. Unit prices, next, Peter. Unit prices are often used when we know the quality of an item, but we don't know how many are going to be needed. So for example, if we have an area, a large area of a building where we know the owner has selected a specific light fixture, but we don't know how many we're going to put in because we don't know the light levels that are going to be needed yet. So that way we'll put in here, say, $100 per fixture. And once the number is determined, we'll then have a sum to add to the contract sum, again, via a change order. Next. Now, liquidated damages can be kind of a complicated issue. What this is really is an amount that's agreed to up front to offset any damage that might occur, the owner might incur because of a delay in the project completion. Next. So, for example, where are you, Pete? I think back one. Yeah. For example, we might have lost revenue. A retail building will provide the owner with a revenue stream once it opens. So if that building is not open by the date that the owner expects, they're going to actually be losing money. Next. So the thing is that kind of a loss is actually a consequential damage. It's a damage that is in consequence of the delay in the project. Those kind of damages are usually waived. The A201, for example, has in its boilerplate a waiver for consequential damages, meaning that the owner can't sue the contractor for that or can't make a claim for consequential damages. Now, often the owners will strike this clause out, but it is really a good idea to have it in and deal with it in liquidated damages instead. So the liquidated damage clause is an upfront agreement that provides the owner a remedy for the fact for that real loss that they may incur if the project is delayed. So really, you can look at it, it's a way of resolving a dispute without a dispute. Next. It's important to understand that this is not a penalty. And it's important to always treat it that way, because most jurisdictions, in most jurisdictions, a penalty is not in a contract, is not enforceable. So instead, this is an agreement that we are going to that the contractor will pay the owner a certain amount for each day of delay. Next. Now the A503, which is a guide to mostly to the A201, but also to the 101, deals with this sort of thing in quite a bit of detail. And in fact, there's language that you can copy and paste from the A503 right into your A201 or your A201 that deals with certain scenarios of liquidated damages. Simplest one is that we're simply going to pay, the contractor is simply going to pay the owner X number of dollars per day after the date of substantial completion that was agreed to. There also might be a variable for over the period. For example, a retail store might be, the agreed substantial completion date might be November 15th. If it goes beyond the end of November, we're getting into the Christmas season, and the revenue stream that the owner can expect is a lot higher, so their potential loss is higher. In that case, the amount, the rate might go up at the end of November. And there can be other scenarios as well, but these two are the major ones. And again, if you have the A503, which you can download, you can copy and paste these two clauses right out of the 503 into the 202, pardon me, the 201. Next.
So Article 5 talks about payments. Generally speaking, the contractor is going to want to get paid. So there's some details that will be set down here in the contract to establish the regular pattern. For projects with a longer period of time, 12 to 24 months worth of construction, the contractor is going to be looking for a uniform way in which the cash is going to be coming in. The typical scenario, as recognized in this form, of course you can modify it, is that there's generally speaking one payment per calendar month, and if you don't approve that in 512, you can insert a different means. In 513, you might begin to identify which day of the month the application for payment has to be received by the architect, and how long the architect has to review it, and before the contractor is entitled to be paid. So these are details that you're going to want to sort out when you're executing the contract. Related to the payments, the contractor is going to be submitting their application for payment, and that is another AIA document. It's AIA document G702. It's actually a dual purpose document. It begins as an application for payment, and then once it's signed and by the architect, it then becomes a certificate for payment. So it's a dual purpose document. And then there's another document that goes with it as backup pages. It's the G703, and this document constitutes the schedule of values. So you see in section 514, each application for payment shall be based upon the most recent schedule of values submitted by the contractor. And in here, you can list all the different trades, what their total dollar value is for each of those trades. And then each month, you can indicate what % complete each of those trades are individually. And if you're filling out this form online, it's a smart form. It will do all of the math for you. So if you've got 27 different construction trades, with 27 different levels of completion. It will figure all that stuff out and give you a total down at the bottom. So when calculating payments and retainage, the fee is the contract sum amount that you're going to be paid on is built up first. And this is listed in 5161. So you begin by looking at the portion of the work that is completed for the entire project. And you then might include the portion for materials and equipment that has been delivered and suitably stored at the site. And I will tell you that A201 says that once the owner pays for it, that the title for those materials and that equipment switches from the contractor over to the owner. So that's an important insurance provision. And then the third component of building the fee up, the contract sum up, is the portion of construction change directives that the architect has determined are reasonably justified. So then we begin to reduce from that and try to calculate what the amount is that's due in a particular month. So you reduce the contract sum by the amount that the amounts that have been previously paid by the owner. You reduce it by an amount for work that remains perhaps uncorrected, for which the architect has previously withheld something on a certificate for payment. You might reduce it by an amount that the contractor does not intend to pay its subcontractors or material supplier, unless the work has been performed by others that the contractor intends to pay. And then you're going to take out work that is performed or defects that have been discovered since the last payment application. So something new might come up, some new defect that you had not noticed before, something that had been previously approved and paid, but now you're seeing that in fact that portion of the work has a problem. And then lastly, you're gonna take out retainage. So retainage is explained here, and I will tell you that you need to check the laws of your state to see what limitations they may place on the maximum amount of retainage that you can put in. A lot of people put in 10%, but Massachusetts limits that to 5%. So this is the amount that the owner is going to withhold to allow for the potential to correct work that is incomplete or improperly installed, which may not be discovered until towards the end of the job. Within the retainage section, there are rules that you can establish. You can give a list of things that are not going to be subject to retainage, such as the costs of general conditions and insurance. You're going to indicate ways in which you might accept a limitation of retainage. That there could be a stepped retainage, 10% for the first 50% complete, and then 0% afterwards, so that retainage eventually winds up being 5% at the end, just prior to substantial completion. So you can put a formula in that 5172. And then lastly, you can list any items that would not include retainage. So there are some additional miscellaneous payment provisions. The contractor might be able to receive additional amounts for delays that are not the fault of the contractor. The contractor is not allowed to make advance payments to suppliers of material or equipment that aren't either delivered or stored at the site. And then lastly, you can insert the interest that you'd like to charge on any payments that are not paid within the time frame stated in the contract. Or you can just simply not fill anything in, and the interest rate would be the prevailing rate, the prevailing legal rate where the project is located. The final payment, so while there may be a certificate of substantial completion, there is no such thing as a certificate of final completion. There's simply the final payment application and certificate. So these are the conditions that are listed here that must be fulfilled in order for that final payment to be issued. And then 522 says, generally speaking, that the contractor should be receiving that payment within 30 days, but there's an opportunity to put some additional statements in here that might affect that. And then the last thing that's sort of related to payment is the issue of termination, and in particular a termination fee, which we find in section 7.1.1. All of the descriptions for how termination might happen by either party or suspension by the owner, all of that is spelled out in detail in Article 14 of A201. It's a fairly lengthy section, and it gives the rights and responsibilities to both the owner and the contractor. So you would need to familiarize yourself with the text of that section. And now the termination fee, if the owner and the contractor agree that they want to not have any disputes in the event of termination, they just want to simply say, if the contract is terminated, pay this amount. That amount can get put in here, or it could be a formula, something that's a little bit complicated or related to at what point in the project you're terminated, like, you know, you've just mobilized but not really done any work. Your termination fee might be something, and something quite different from if you're halfway through the project, or for that matter, very near the end, and about all you have left to do is punch list work. So we see in 7.2 also that the owner has rights to suspend.
So then we get into what happens if things go sideways and we can't agree. So Article 6 deals with resolving this kind of dispute. The usual process is that, well, first we talk about it. If that doesn't work, we go into mediation, and if that doesn't work, we go into something more forceful. Some published contracts have an actual clause to meet and confer in them. When we were writing the 201, we decided that was superfluous. If people aren't of a mind to try to work things out by talking it through in the first place, requiring a meet and confer in the contract isn't going to help things. They're going to get together and say, well, okay, we've met and conferred, now let's go to mediation. Most of the A201 then also requires mediation as a precedent to any kind of binding arbitration or litigation. Okay, this is a little bit more forceful meet and confer scenario where we're all talking, but we have a mediator to help decide what is reasonable. If that doesn't solve things, then we'll go to either arbitration, binding arbitration, or to litigation. And in 6.2 there, you have the option of selecting one of those scenarios. There's also an other checkbox. Some state jurisdictions and so on have various requirements around disputes. So that would be what you put in that fill point there under the other scenario. Next. The last piece of this then is the insurance and bonds exhibit. This is a really complex issue, and most architects really don't have an in-depth knowledge on this. It used to be that the insurance and bonding requirements were embedded in the contracts themselves. In the 2017 version, it was decided to take that out into a separate a separate document that could be attached to the contract itself. This does simplify things quite a bit because you can take this document then to your insurance broker who does have the expertise, or hopefully has the expertise in this issue and how it's going to impact the project. And they can advise the parties directly on what kind of insurance and bonding the project should have. There's also within the document itself, there's quite a bit of instruction and guidance on how to complete the exhibit. Next. Then we have other exhibits to the project. We have Exhibit A, and then we may have, for example, if the project is a sustainable project, AIA provides an exhibit, the A204, for a sustainable project that is attached to the A101 then. And that in turn requires a sustainability plan, which then is also attached as an exhibit. There might be a digital environment exhibit. AIA provides the 203, which talks about general digital issues that can be determined at the beginning of the project, and then the G201 and G202 forms that deal with things that will evolve during the project. So the G201 deals with general digital data, and the 202 is where we get into how exactly we're going to use building information modeling in the project. This also has a guide that can be downloaded for free from the document site on how to complete these documents. Another exhibit that you might often have is a drawing list. As we mentioned before, every sheet of your contract drawings becomes a contract, so they have to be listed succinctly here. Article 915 has a fill point for this, but major buildings always have hundreds of sheets of drawings. It gets pretty cumbersome to list them in that fill point. So most firms for a major project will simply list the drawings and the specifications on another form and attach that as an exhibit. Next.
So now we're going to go through how to complete a sample A101 using Microsoft Word. So when you log into the AIA software, you're able to edit the document online, or you have an option that I always take, and that is to download the document, download a Word version of the document, and then you can modify it. It will track your changes. You can send it back and forth between the parties, and each entity or person that works on it and marks it up, their markups will show up in a different color. You can insert comments into the document. So a lot of the protections that used to be in the older version of the AIA software, the desktop version, those have now all yielded to just being able to modify the document using Microsoft Word, and you can turn track changes on and off and not need the software any longer. So as you're filling the document out, the first page tells you the characters. Of course, you want to get the date for the contract, the name of the owner, the name of the contractor, a brief description of the project if you feel you might need to put a little bit more flesh on those bones. You can reference a longer document to describe the project rather than try to type all that into this fill point. And then you list the architect who's going to be involved in the project. And all the architect's responsibilities are explained in A201. So, so we come into the main part of the contract here. I've indicated that on execution, we don't know when the notice to proceed is going to be. So I've put my little X in here, indicating that the date will be established once the owner issues the their notice to proceed. Because of that, because I don't know the actual starting date, I know it's going to take me a year to get this project constructed. So I've put my X in here, and I've indicated that the project will be complete within 365 days. There are no separate portions of the project that I want to take individually. So I've just simply said that I want the whole job finished on one date. So this section here is not applicable. You can do that. You can just put not applicable in any of these things. If in this case, because we're not going to have liquidated damages, I've struck this clause, and I don't like to delete entire clauses, which I can. I like to delete the clause and say intentionally omitted, because the AIA software doesn't generally like it if you delete section numbers or renumber your documents. When you go to produce the final clean version, it's not very clean if you do that. So that's my little bit of Microsoft Word geekism for you. The contract sum gets filled in here in both in words and in amounts. In this case, we had two alternates on the job, one that we accepted right away and one that we're not sure whether we're going to accept it on time. But in this case, we've established a parameter that the owner must authorize this alternate prior to erection of the third floor steel. Because after that, I'm just simply not going to know where or how to put the holes in the floor. You can come up with any kind of a condition for acceptance that you want. It can be a date. It can be, within 60 days, the owner must authorize this, and that might be because of the deal that you have with the subcontractor. Allowances would get filled in here. In this case, we haven't gotten around to selecting which particular marble that we like, and we haven't had a chance because of the coronavirus to go to Italy to pick it out, but we think that a reasonable allowance is $50 per square foot, and that would be for material only. For unit prices, we think that they're based on the borings that we've taken, that there might be a rock under various parts of the area of the basement that we're going to have to excavate for, but we're not sure because all that is hidden below the ground. So we put in an allowance here for a certain amount per cubic yard, and we'll reassess and adjust the contract sum at a later date once we've dug the hole and seen how much rock there actually was. Here we've excluded liquidated damages, and there are no other provisions, so we just simply put not applicable here. For the payments, I'm very happy with the once per calendar month scenario, so there's no reason to make reference to some alternate method that might be used to compute when the payments will be processed. We've said here that as long as the application for payment is received by the architect no later than the first day of the month, that the owner agrees to pay the contractor by the 14th day of that same month. So, and then if the application for payment is received by the architect after the date above, then this amount certified will be paid not later than 7 days after. So there could be in one particular month, for whatever reason, we didn't get it by the 1st, we got it on the 7th, so then the owner would get, well, it would still be the 14th, but you get the gist of what I'm talking about, that there needs to be some sort of flexibility, and it's covered pretty well in here. Retainage, it could be a simple amount that's plugged in here. This would not work in Massachusetts, like I was saying earlier. Items that we've listed that are not subject to the retainage are the general conditions and insurance, and you might well have others. For reducing the retainage, So we plugged in a formula here, and I happen to get this from the guide for the A101, which is a part which we'll explain in a little bit. So this is some suggested language that says that until the time of substantial completion, the owner may withhold 10%, as applied to each line item in the schedule until the line item is 50% complete, and thereafter at no additional retainage. So that would be then a reducing amount from 10 down to 5%. If you did that math, you'd be able to figure that out. The owner may continue to retain some portion of the retainage to cover remaining work to be completed, let's say where bonds have been provided by the contractor, the consent of surety shall be obtained. So these are some conditions that have to do with retainage. Lastly, the owner's final payment shall be made no later than 30 days, and I've just simply made that into a statement. I've not used this fill point. Here, I'm happy to go with the legal rate of interest for any amounts that are overdue. We can take out the initial decision maker, which so many people do, but again, take it out, leave it. Don't take out section 6.1 and then immediately it goes to 6.2 and somebody says, what happened to section 6.1? Leave the title, say it's intentionally omitted. For the binding dispute resolution, you can indicate here what the method is. And actually, there has been a court ruling, I believe it was in the state of New Jersey, that said that when you put the X here, you didn't have to delete arbitration or this other thing. The court allows or accepted in that one ruling that this X actually means something, and you might add some other text, whatever your attorneys involved in it feel is appropriate. For termination or suspension, I plugged in here a complex formula, and this does come from the guide, so you'll see that that this is available, that shows how the termination payment might be reduced over time. There's a space here in Article 8 to list the representatives who are answerable for both the owner and the contractor when it comes to anything related to the contract or key decisions that have to be made. You can insert here your notice provisions. This is an old-fashioned method via certified mail. If you want to accept notice via email or anything else that your attorney might find reasonable, you can plug that in. And then finally, there's no other provisions, but finally here we begin to list some of the things that we have at the end. You can cross out any exhibits that you're not going to have. You can make reference to exhibits. Here I've listed the drawings in a separate exhibit that doesn't have to go through the AIA software, and it can be modified later as the job changes when, by means of change order. And do the same thing for your specifications. In this case, there weren't any addenda. And then lastly, some other exhibits. You might insert your project description or any of these other standard forms. And then lastly, you put down here the people who are authorized by the company to execute contracts. So when you're working on this thing, you notice that it looks very messy. You got this draft watermark on the side here. And if you print this thing, there's also a draft mark up at the very top of the contract. This is obviously a preliminary thing, but when you have finalized the agreement, you can send it through the AIA software, and that then gives you this nice clean version with that beautiful AIA logo, and there's this AIA watermark on every page, so you can see that this is an authentic document. The document is protected, it can't be modified, and wherever changes are made, there's a little vertical bar next to the highlighting a change was made, but it doesn't tell you what that change is. Now, if you keep scrolling all the way through to the end of the document, you come to an additions and deletions report. And this begins to show you all the items that were filled in and any text that was stricken. Once you become familiar with an AIA document, if you're trying to figure out, well, what did they change? Because all you've seen is the clean document, you can look in this additions and deletions report and be able to find where the changes were that were made. So
yeah, if I could add in here, Pete, this change report becomes pretty important because, for example, when we were developing the 201, as is our usual process, we first went out to several large contractors to get advice on it, and many of them told us pretty much word for word that if you hand me an unedited AIA A201, we'll sign it in a heartbeat. So they become very familiar with the standard document, and all they really need to do is look at the changes to see if there's anything that they disagree with.
Okay, so we've completed our sample document. I will tell you that there's a host of very valuable resources that would give you a lot more information about the A101 than we talked about in today's meeting. If you're in the AIA software, just click on Help, and you can go there and you can search for the guide, or in this case, the instructions on the A101. And after you've found it, bring it up. You can see there's a little synopsis on the document. There's a description of what each of the items are that have to be filled out within the document. Then there's another very helpful document, the A503, and this is a free download. I strongly recommend that you get a copy of it. It has very informative articles. In this case, we've got one highlighted here about the topic of liquidated damages. There are advisory comments, things that you're going to want to talk about with your attorney. There's model language that you can copy to the clipboard and paste into your document so you don't have to retype it. And that is our presentation. Kosti.
Great. Thank you, Peter and Jim, for that thorough and extensive webinar. So what I'm going to do now is invite attendees to enter any questions within the question window on the right-hand side, and we're going to answer as many as we can. Just please note that you will receive the PowerPoint and recording by COB tomorrow, so you will be able to access these as references in the future. This and other education is also available on demand on our Learn page. So if you go to www.aiacontracts.org/learn, you'll be able to find additional education, and this course will be uploaded by close of business today. If you have any questions that we can't get to today, please don't hesitate to contact docinfo@aiacontracts.org. That's our content line. If you ever have any questions about any of our documents, what a provision means, how to complete a form, docinfo is where you'll send those inquiries. Any questions regarding the online service can be sent to technical support. So with that, I'm going to go ahead and now open it up to questions. And our first question is, the document states that the contract is between owner and contractor. What is the person paying for the work? What if the person paying for the work is actually a tenant of the building? Can we assume that we can just change owner to tenant?
Yeah, let me take that one. Great question. It's probably best to leave the form alone, because otherwise you'd have to do a massive word search and roll through the whole thing. I have seen situations where tenants enter into contractors and they are not the owner. If you have any insecurity about that, you can clarify that within the document. You could say the owner is a tenant to the building, but for the purposes of this document is referred to here and hereinafter as the owner.
What comes first between substantial completion and certificate of occupancy?
Pete, you want to take that one?
Sure. Okay, so in order to obtain a certificate of occupancy, some jurisdictions are going to want to see either a final affidavit or a G704, which is an AIA certificate of substantial completion. Usually, you know, these sorts of things get known about, get planned, get discussed between the owner, the architect, and the contractor in the last couple of weeks leading up to when everybody's talking about the particular target date for the substantial completion. The architect has to have completed all of his punch list. He has to, if he's got consultants, he's had to have them go out and complete their punch list. And the parties have to determine that there's no encumbrance to the owner legally occupying. So if, for example, the life safety systems in the building are incomplete, then the project is not substantially complete. So the project must be completed in order for the owner to legally occupy and use the project for its intended purpose. So assuming that all of that key work, and the contractor should be well aware of what all that key work is, assuming that all of that work can be done by a certain date, then all the punch listing work can be done and complete by the contractor, and then verified by the architect and the architect's consultants. And nothing on that list then is a life safety issue. Then the architect is in a position to issue that certificate, and that certificate and/or any other affidavits that they might have to prepare can be submitted to the building department, and then the building inspector will do their walkthrough and issue their usually a temporary certificate of occupancy, but in some cases it might be the final.
Okay. When using the contract A101, can the architect read this contract, or should the owner not share it?
That is a great question. In the owner-architect agreements, it says that now unless it gets modified, it says that the owner is going to share a copy of the contract with the architect. Now, if the architect is going to be reviewing and approving certificates of payment, any issues of confidentiality with respect to payment are gone. The architect is also going to have a role in reviewing change orders. So again, that's talking about money. The architect has to be aware of that. So if you read the B101, it says that the architect is the administrator of the contract between the owner and the contractor. So in that situation, if you're an architect and the owner is not sharing with you the contract, and in particular the general conditions, then I think you're well within your right to say to the owner, Mr. Owner, I am the administrator of the contract. I'm not the administrator of the construction. Let's not go down that misnomer that everybody says that we do construction administration. We actually administer the contract. So, Mr. Owner, I can't administer the contract hardly without seeing a copy of it.
Can we insert an award against the liquidated damages if the contractor finishes the project early?
Jim, you want to take that one?
That's a great question. That is becoming more prevalent now as an incentive. I not having a copy of the document right in front of me, I can't point you to the exact clause. Maybe Peter, if you can bring that up.
Yeah, there is a full point.
If you know where it is. Yeah, but in fact, that is a very good idea. Sometimes we talk about that guaranteed maximum price contract. There is often an incentive put in as a shared savings that if the price comes in under the GMP, the savings will be shared, for example, between the owner and the contractor 70-30. So this gives the owner or the contractor an incentive to an incentive to finish early or to finish under budget. So there you see, Peter's got it highlighted. Yeah. Article 4.6, other provisions for bonus or other incentives. So I think this is becoming more prevalent than it used to be.
Okay, so unfortunately, those are the only questions we can get to today, and a great number of questions have come in. So I do encourage you to email any questions we couldn't get to docinfo@aia.org. Please note that you will receive the PowerPoint and the recording by email by COB tomorrow, and the recording will be uploaded to our Learn page. Also note that if you are an AIA member and indicated your AIA member ID, your credit will be reported to the AIA within 1 to 2 business weeks. If you have any questions, please don't hesitate to contact us. Thank you very much for your interest, and thank you to our excellent presenters today for taking the time to present today's session. Have a great afternoon.